So we'll be looking at Chapter 1, which looks at psychology and the law in regards to choices and roles. So again, this is your instructor, Mr. Barber. So without further ado, we'll be moving forward. So why psychology and the law? So again, if you'll notice, according to the APA 2020, the law and psychology are two separate disciplines but have much in common. While psychology's goal is to understand behavior and law's goal to regulate it, both fields make assumptions about what causes people to act the way they do. Again, many psychologists research how to improve the legal system. So again, that's one of the things you're kind of looking at, the intertwined nature of psychology and the law, because one proffers element of behaviors, the other one tries to regulate those given behaviors. So this was back in 2012. So this is the Batman premiere in Aurora, Colorado. So this is where an individual by the name of James Holmes walked into the midnight showing of the movie Batman, and this is how he primarily dressed. He had the ballistic helmet, tactical vest, ballistic leggings, metal shin guards, armored boots. Walked in with initially all of this, the ammunition, even just the weaponry and everything else, primarily was all bought from online vendors. And so within that, you kind of know the uniqueness of online purchases in terms of how easily a lot of the weaponry was kind of easily purchased. But within that, walked in, armed like the figure to the left. He held the theater hostage to kill 12 and wounded 60 others. So again, you notice the tactical elements. You notice just the mindset in terms of the initial direction, the singular objectivity, and everything else. So again, this is a man with a plan. So again, the initial individual was one James Egan Holmes. Again, legally purchased all the firearms. And again, that's where individuals kind of go into the area of gun safety. You know, should we allow this, that, and the other? And again, that's not for me to say, because again, I look at the element of everybody does have that initial right. But again, you also look at the mental health of individuals. And so within that, you kind of, when you look at this initial image, you're looking at all this different level of weaponry and the initial thought that went into that. So again, it's primarily the element of just an individual that initially went into the theater with, as the note says, a man with a plan. So again, this is the individual, James Holmes. So why did a reclusive PhD student attack a theater full of moviegoers? And again, this is an individual who is highly educated. Again, he's working on his PhD. His life may have become overwhelming, causing him to withdraw from his graduate program. Holmes may have harbored psychopathic traits that went undetected by people who knew him. If you look at the area of psychopathy, a lot of times it goes into the area of manipulation and being able to hide a lot of those various discrepancies. If you take abnormal psychology, we go into the area of the uniquenesses of the mind itself and how psychopathy and sociopathy kind of almost go hand in hand in terms of the ability to manipulate. So again, that's another possibility in terms of the individual for James Holmes. So again, meanwhile, in Arizona, if people don't like our immigration law, they're going to hate our new police uniforms. Again, a law in Arizona allowed police to stop anyone they suspected of being an illegal immigrant. So again, research indicates that Hispanic residents of Arizona are now less likely to report crimes for fear that they will be harassed by police. And a lot of times that's really what it comes down to. The element of, if I am going to report a crime, how is it going to impact me? Am I going to be harassed by the police? Am I going to be harassed by other individuals? Again, those are the things that kind of play in as well. So in Dallas, after a 10-year-old was killed by a drunk driver, Again, the driver was sentenced to 180 days in jail over the next 10 years. Again, these were Christmas Day, New Year's, June 8th, the child's birthday. Again, the judge wanted him to reflect on the child's family's loss. So the importance of laws. If you look at the gun-free zone, for a lot of schools, you have, and this is all not even now. So if you go to various schools, you have gun-free zones, and does this deter individuals? And a lot of times it's a mixed feature, because what do gun-free zones kind of promote? It promotes the fact that there will be no firearm on the initial campus, which would indicate that if an individual, like say for example James Holmes, were to figure that and say, hey, is this a possibility? Is this a possible viable location where I can go on to and cause the most damage? And that can be also another reality, because response time, even if you look on the Navajo Nation, response time is pretty low. In that, because of how vast the Navajo Nation is, the ability to respond quickly is going to be limited. And so within that, laws as human creations. Laws are humans' creations that evolved out of the need for order and consistency. And I think that's one of the things that we kind of notice. If even for Navajos, we have various law systems, we have various levels to create order. And again, the laws regulate our private lives and our public actions. Our laws change with the needs of society. Before there were any school shootings, guns and other weapons weren't banned from school grounds. But again, since the mass killings of the last decades, our laws now prohibit weapons at school. And this can go even farther. There's various schools that I've worked on that even limit things as far as sharpeners, pencil sharpeners, because they can use the little razor in there to either inflict harm or even to use it on themselves for suicidal ideations and stuff like that. And so these are kind of the things that kind of came about even prior. Like say, for example, if you look at 9/11, before 9/11, security was pretty lax. You never had any issues with going into public locations, courthouses, hospitals. But after 9/11, things kind of changed. And now even more so. The laws change even more in terms of COVID. You have individuals who have pushed the law system even farther. When we go into the store or anywhere else, we have to make sure that we have a mask, or all these different distinctions that kind of change based upon our given needs, based upon society's needs. So laws again help resolve conflict and protect the public. We believe. So again, laws resolve the conflicts between one person's impulses and other people's rights. Public safety is always a consideration in a civilized society. And again, before laws, people pretty much took matters into their own hands. So again, you have a listing of various movies that primarily look at the vigilantism. Even on the Navajo Nation, even in various locations on the res, you'll find that there's different locations that actually still utilize vigilantism. The reason being that, as I noted before, law enforcement is pretty limited, and due to the limited response time, a lot of times individuals have indicated, well, I'd rather just take it into my own hands, because a lot of times the offender, perpetrator, etc., simply gets a slap on the wrist. Therefore, I feel like as a vigilante, I'd be able to get more done. And so again, that's where you also have uniquenesses that happen across the board. So you'll find that the importance of laws, when you look at the changing of laws, a lot of times it changes due to the fact of, if you look at over to the right, just due to that, you have individuals who are now being proven innocent based upon the changes in terms of DNA usage, brain imaging machines, analysis of trace evidence. And even prior, you had individuals who were claiming their innocence. And again, that's one of the uniquenesses of an individual who is incarcerated. A lot of times they'll indicate, I am innocent. But again, it comes down to the element of, how many cases are currently pending right now that initially the individual is actually innocent. Again, you have 300 exonerations and counting. So again, this is due to DNA evidence. So again, 4,013 years in prison on average of 13.6 years per exoneree. So again, over 70% are people of color. 33 were under 18 when arrested. A lot of times you have young juvenile crimes. Again, 28 pled guilty to crimes they didn't commit, and 18 were on death row. Within that, 4,000 plus prisoners have written to the Innocence Project, and others each year asking for help with their cases. So again, like I said, the laws are changing, as well as the ability to re-examine cases as time continues. So again, laws keep changing and trying to keep up with the changing times. Legislators must now consider what restrictions should be in place on online activities. So again, it's one of those uniquenesses where more than close to about 28 years ago, the internet was barely invented. But within that time, we've seen massive change. For example, when you look at even your cell phones, a lot of times even the fact of using text and everything else, more than 10 years ago, you asked grandpa and grandma to text, that would have been very foreign to them. But you look at them now, a lot of them, that's how they're communicating with their grandkids. That's how and we can try to hold on to the element of, we're trying to go back to the past. But if you notice, the reality is we're consistently changing, we're consistently evolving. And so within that, that's the reason why the laws at times have to play catch up to the evolving times. But if you notice, the times itself will continuously evolve quicker than the laws. Say, for example, sexting has become a crime after people have sent nudes of themselves to underage individuals. So if you look over to the right, talk dirty to me, garbage can, laundry, kitchen. So again, this is kind of a play on words and everything else. But you'll notice that even in regards to this, if you look at the younger generation, there's a greater calm. There's a greater calm in terms of sharing a lot of these information, sharing a lot of the things that we, maybe a little bit older, feel should be held private. But if you look at the younger generation, they're able to share a lot of that. Even now, more so, because in light of COVID, there's now a greater need to utilize online formats, to use Zoom a lot, to use TikTok, to use various online social media outlets. And what can happen is they become so comfortable sharing online that they don't realize the impact it can have even in their personal as well as their professional life. So the psychological study of the law. Again, a psychological approach to law emphasizes its human determinants with a focus on individuals as its units of analysis. Again, individuals are seen as responsible for their own conduct and as contributing to its causation. And this is where psychology examines the thoughts and actions of the people involved in the legal system. Again, that's where you're looking at, what was the thought at the given time of the crime, or does this individual understand the initial consequences of their actions? So psychological study of the law, when you look at drug abuse, a lot of times you're wondering, does this individual know the impacts of what's happening? Whether they're using cocaine, whether they're using heroin, whether they're using methamphetamines, whether they're using marijuana. You see all these different changes. And so that's where the psychological study kind of comes in. So petty theft, here's another one. Individual initially stealing things. So again, how much of an impact does that have? Is it harming anybody? Is it only harming the individual or the company that is losing money because this individual is stealing from them? Or does it go even farther? So here you have the purpose of psychological screening. So you're looking at general intelligence. I can't even speak right now. It's general intelligence, judgment, prior drug use, and integrity. Again, it's looking at this testing for personality traits. But what screening is not is to determine if a person is crazy. So again, you're looking at individuals. But again, I believe it's about 5% that are screened out due to various issues. But overall, majority of the testing is done to ensure that law enforcement has a level of discrepancy, but also that they were examined to a certain extent. Does that mean it's foolproof? No. Again, due to the high rate of distinctions that happen within law enforcement in the field, it can impact their ability to do the job and everything else. And so within that, those are the various elements that kind of have to be taken into consideration. Because a lot of individuals will criticize and say, well, the police officer was screened, therefore, they should, be able to do the job with integrity and ... But understand that due to the fact of, and the same thing applies, like say, for example, individuals who are working in the military, due to the high levels of stressors, again, it can change and alter the mindset of an individual. So again, that can also impact a person's ability to perform the job. So again, those are kind of the other distinctions. So here you also have the psychological study of law in regards to victims, in terms of victim crimes, in terms of victimology, in other words, the study of victims and their response to a given crime scenario, or even just the crime itself or the issue at hand. So again, each individual may respond differently. So that's the reason why we study crime. We study also, so that would be criminology, but we also study the victims in terms of coping techniques, in terms of their interpretation of what had subsequently happened, and also moving forward in terms of their behavioral features, in terms of their mental processes and stuff like that. So here you also begin to also study the psychological elements of jurors, in terms of juries, in terms of jury selection, in terms of which way an initial ruling may end up favoring. There's a show called Bull, which kind of looks at those elements. It looks at it is a fictional show, but again, it takes into account the elements of jury selection, in terms of behaviors, in terms of the psychological features, in terms of jury selections, in terms of even judges, which way the judge will end up swaying in terms of their initial ruling. And then you have expert witnesses. So you have fact witnesses and expert witnesses. In other words, in my expert opinion, ... and fact witnesses, which initially are pressing the elements of what needs to be applied. So overall, you're kind of looking at all the different elements that kind of go into the study of psychology and the law. And then you have corporate lawyers. At times you have individuals who initially work with various organizations. Again, you're also looking at which way an individual may end up going in terms of their selection of a given product, or in terms of going forward in terms of the legal ramifications. And then judges. As noted, we have judges that will initially favor based upon their own internal beliefs. Believe it or not, judges are simply that. They're human. So within that, you have individuals who be swayed. They can be swayed by various factors. So here you have the psychological studies of defendants. A lot of times you're looking at the unique features of defendants in terms of their crimes, in terms of what actions have taken place. And so a lot of times you're looking at those elements, and you're looking at the elements of also do they understand what had happened in terms of the crime. And a lot of times, from a layman's standpoint, we look at it from the angle of, well, of course they should know what they did. What they did was wrong. But if you delve deeper and deeper into the mindset of an individual or offender, you'll find that there's more to it than the initial bare bones. So again, that's one of the things you kind of have to differentiate and everything else, and that's where the psychology of law helps in those matters. And you have prison guards. In other words, you have individuals who work in the prisons or who work in correctional settings. And so within that, a lot of times you're looking at the impact to their mental health. You're looking at the impacts of how their mindsets can play into their job. Because again, it's a highly stressful location. And the reason why I say this is I used to do a lot of work with local correctional facilities. And within that work, a lot of times you're seeing the impacts. You're seeing the psychological health decline. You're seeing the stress. You're seeing the reason why is you're around individuals who initially have committed various wrongdoings, and when you're around that level of stress, a lot of times your mental health will also take a hit. And so that's what you're also taking into account is the ability to make rational and also actionary decisions in a quick manner. And so you're also looking out for the safety of the inmates themselves. So that's one of the things you're also taking into consideration as well. And parole officers. My work at times was working with domestic violence victims, but you also have parole officers who a lot of times their job is to make sure that the individual that is on parole maintains the various appointments and everything else. But you also see the impact. You see the psychological health, just like I was noting with the individuals who work in correctional facilities. A lot of times their health also declines. And so you're trying to take care of those things. You're trying to make sure that there's various outlets in terms of coping strategies, in terms of making sure that the individuals that are working in that field are able to take care of themselves and also able to make rational decisions. So here you have the psychological study of law, but you're looking at the uniqueness of how the legal system kind of affects primarily you're looking at various characteristics actually of participants in the legal system, and primarily looking at how the legal system primarily operates, but you're also taking into account the psychological characteristics as well. So again, you're looking at characteristics in this case, primarily looking at the abilities, perspectives, values, and experiences. A lot of times you're taking that into account because, again, due to the uniqueness of the law, each individual will kind of have their own interpretation of what's going on. And so when you're taking that into consideration, no one case will be similar to the other. Again, across the board, you're going to have different laws that kind of hopefully offer that level of application across the board. But again, each individual will kind of interpret themselves differently. And through that understanding, you're kind of getting a better sense of the initial mindset. You're looking at the perspectives, and you're taking all of that in consideration so that you're able to apply a more detailed outlook, whether you're doing an examination, an assessment, whether you're assisting in the defense team, whether you're assisting with the prosecutor's office, stuff like that. So characteristics, characteristics determine whether a defendant and their lawyer will accept a plea bargain, or rather, if they'll initially go to trial. A lot of times, most individuals don't necessarily go to trial. They'll a lot of times look at the plea bargain and kind of go from there. A lot of times, for Law and Order and a lot of different TV shows, you're always seeing them go to trial. But the reality is, trial is expensive. So within that, you have a lot of individuals who will kind of go from the other route and say, okay, what would be a better deal? And so that's where you have a lot of individuals kind of go that route. So again, characteristics. What do they determine? They determine whether a Navajo juror will be more sympathetic toward a Navajo defendant than toward a non-native defendant. So again, when you're looking at those things, you're taking all these different things into consideration. You're taking into consideration that of race. You're taking into consideration ethnicity. And I know in our day and age, we try to look at things from the objective of, race does not matter, ethnicity does not matter. We shouldn't look at those things. But the reality is, in very simplistic terms, they do matter in terms of the legal system. That's the reason why, for a lot of times when I used to work with victims of domestic violence, the element of clothing, the element of presenting yourself and everything else play into the presentation. And so again, if you look at a lot of times, if you watch a lot of crime shows, and they go to trial, a lot of times you will see the defendant who, maybe was a known drug dealer or a known, human trafficker. All of a sudden, their clothing and their demeanor and everything will kind of change to portray a more sincere individual, an individual who may be more, how would you call it? My mind just literally went blank right now. An individual who's more contained in terms of their demeanor, so that they're trying to present that best foot forward. And so again, it's almost similar to, how would you say, like a first date. You're trying to make sure that you can win over the initial jurors. So characteristics, again, they determine whether a juvenile offender will fare better in a residential treatment or a correctional institution. Again, you're taking that into consideration as well. And I know from a layman's perspective, we simply look at it from the angle of, obviously one will do better than the other. Well, that's where the assessment kind of goes in. That's where you're using a lot of clinical judgment. That's where you're utilizing a lot of different assessments to kind of say, okay, is this individual going to fare better, or will they fare negatively? Will it have a detrimental effect on their overall well-being? And psychological studies. Again, the setting within which the individual operates is important. Social psychologist Kurt Lewin proposed the equation, again, to reflect the idea that behavior is a function of the person and the environment. B equals F times P and E. So again, the behavior of a person in the legal system also can be viewed as a function of both the person and the environment. Again, that's one of the things is you look at all these different impacts. You look at all these different distinctions that kind of that an individual will initially be placed within. And you're hoping for the best. You're hoping that in a correctional facility, the individual will fare better. You're hoping that the setting that they're now placed in, you're hoping that all these different things will kind of line up. But then you also have to take into consideration the realities of it all. And so again, all of these things you're trying to weigh in, all of these things you're trying to implement, all these different things you're trying to account for as you're moving forward. So again, a prosecuting attorney may recommend a harsher sentence for a convicted felon if the case has been highly publicized. That also plays in. Publications, the publicity of it all. Again, the community is outraged over the crime, and the prosecutor happens to be waging a re-election campaign. Again, those things also play in too. So if there's, if a prosecutor is happening to have, going to go forward in a re-election, that plays into their judgment. That's where you have defense lawyers kind of playing in on emotions. Because a lot of times that's all you're doing. You're really analyzing the emotionality of individuals as you're simply trying to offer some level of insight, whether you're working for the defense, or you're working for the prosecutor, or even if you're working for the victim. Bear in mind, the prosecutor is not necessarily working for the victim or working for one side or the other. They're working for the state or even the Navajo Nation. A lot of times I've had individuals who thought that the prosecutor was always going to work on their side. But a lot of times they're actually working either for the Navajo Nation or they're working for the state. So again, they're trying to implement a lot of the laws, and that's where they're primarily working for the people. So again, a juror holding out for a guilty verdict may yield if all the other jurors passionately proclaim the defendant's innocence. Again, that's where you're also taking those things into consideration. How far is a person going to hold out? Again, it's one of those things where an individual may hold out for a long period of time, but eventually the initial mindset will begin to wane and everything else, or they may end up just going for a mistrial. So a juvenile offender may desist from criminal behavior if his gang affiliations are severed. And that's where we always try to look at those things. We look at the element of, and we used to always use that terminology. It's from an old movie, Blood In, Blood Out. And one of the biggest things is you enter a gang, a lot of times that ends up becoming your family. And as it becomes your family, you end up doing different things. But if, say, for example, you're wanting to change your life and you're wanting to get out, a lot of times, at times, and I'm not saying that all of them will do that, but a majority of them will, where you get to the point where you're like, hey, you know what, I want to grow up, I want to kind of get out of this life, and I want to change my life. I found somebody that I do care for, and they're not part of this gang and everything else, and they're living a different life, and I want to go that route. And a lot of times the other affiliates will sometimes say, hey, if that's the case, then we have to either make you suffer really badly, or, and that's where you have individuals at times getting beaten up and everything else. But again, it's one of those uniquenesses of gang life. But it's one of those areas where, even if that's the case, when I used to work with individuals with gang members, a lot of times you're trying to ensure the safety of that individual. And a lot of times it's not only just severing the affiliation, but also having to move just for the safety of that individual. And if you notice, a lot of times the gang affiliations are becoming more and more organized. Even on the reservation, you're seeing things kind of change. You're seeing individuals that are coming from the city who have major gang networks in the city, but now they're coming out to the reservation. And as they're coming out, a lot of times you're seeing a more organized connection. And so that's kind of one of the things that you're kind of seeing as well. In addition to that, you're also seeing, years ago, you used to always look at the gangs on Navajo Nation as kind of like kiddie gangs or whatever. They're not as severe. But what you're also coming across is the fact that a lot of times the gangs are becoming more and more, not so much organized, but more along the lines of they're becoming more hardened. Because some of them have actually served time in prison. And so when they're coming back to the reservation, they kind of have that same mindset. And so within that, you're starting to see individuals take greater chances, greater risk, and everything else. So again, we are all active participants in the legal system. We all face daily choices to follow or break the law. Whether that be speeding, reporting someone we see shoplifting, whether to vote to change a law, such as legalization of marijuana. Even now, even with COVID, we have laws even on Navajo Nation regarding COVID. If you're trying to make sure that you stay safe, you make sure that you don't break the law. And again, we're all active participants. And that's kind of one of the things that we kind of have to take into consideration when we're moving forward with the psychological impacts of the law itself. So, moving forward. So again, this is your text, Reitman's Psychology in the Legal System. Again, this text concentrates on the behavior of participation in the legal system. This book will also devote attention to the determinants of our conception of justice and the moral dilemmas we all face. Again, the main focus will be on the role of psychology in the criminal and civil justice system. So again, forensic psychologists, again, they generate and communicate information to answer specific legal questions or to help resolve legal disputes. Again, you're using a lot of forensic psychologists happen to be individuals who studied clinical psychology. So again, they're applying a lot of that treatment and diagnosing. But again, they're also applying the elements of the legal concepts. So again, lots and lots of terminology. You're consistently trying to better your mind to know enough terminology as you're moving forward. Primarily, that's what you're going to be learning a lot of. Even in this course, you're going to be doing a lot of terminology, studying so that you can pass your quizzes. So again, enjoy. So again, most forensic psychologists are trained as clinical psychologists whose specialty involves the psychological evaluation and treatment of others. Again, these psychologists are often asked to evaluate an individual and prepare a report for court or provide testimony. Again, you're doing a lot of writing. That's where your writing kind of comes into play. If you're using a various judgment, everything else, you're having to make sure that you're trying to be as succinct as possible. That's the reason why I have you do various assignments where I want to make sure that you're not droning on and on about various elements. You want to make sure that you hit the head on the nail, per se, and that you want to make sure that you succinctly share your idea, but you're also trying to grab all the key points. And so again, they're seeking to identify mental illnesses that might affect their ability to go to trial. So who is the most important? One person decides to go into a grocery store without their mask because they feel that they do not have to wear a mask because, again, they have autonomy and don't fear any virus. Whose rights prevailed? Individual rights or the common good? So again, you have individuals who, if you look to the left, you'll find how to wear a mask. Again, you have individuals who still do this. They'll wear it underneath their nose. If you notice, if you know how to wear a mask, it's one of those things where you still have individuals who are breathing out through their nostril. Again, what comes from the nostril, mucus and various particulates and everything else. And if you wear it on your chin, it's not really helpful. It's not a chin strap. If you wear it on your chin and you sneeze, you have individuals who have a mask, but they'll have it on their chin and they'll actually sneeze into their arm sleeve. And you're looking at them thinking, really? So you kind of have a mask there. And you have others who simply wear it over their eyes. And again, which one weighs out? Individual rights or the common good? So again, there are 4 basic choices that pervade the law in the U.S. and in many other countries. Each choice creates a dilemma and has psychological implications. The first one is the rights of the individual versus the common good. The second one is equality versus discretion. Third one is to discover the truth or to resolve the conflict. And fourth, science versus the law as a source of decisions. So again, here's another example. Smokers are now banned from lighting up in some public parks and beaches and along shorelines and trails. Should cities be able to limit smoking in public area? And should smokers' rights or non-smokers' rights prevail? If you notice, if you go to IHS a couple years ago, there used to be an area where it had a little smoking area. But as time progressed, they changed it to where you have to smoke off the campus. You have to make sure that you're off the campus and everything else. And again, all of these things kind of play in, the rights of the individual versus the common good. And then the rights of the individual versus common good again. Some cities have banned what they refer to as sagging pants. And when I used to work with gang members, one of the quickest way that you could get gang members to initially, because again, it always became an issue. Because again, if you wear your pants properly, hopefully your pants kind of sit at your waist level. But if you notice, most individuals used to wear it a lot lower to the point where you would see boxers and underwear and everything else. And one of the quickest way you could get an individual to pull up their pants was just to indicate, hey, you have a stain on your underwear. And again, within that, you had individuals who quickly would pull up their pants and everything else. But again, some cases have actually gone to trial for breaking the decency ordinance. Again, is it a question of freedom of expression? Does a community have the right to set their code of decency more conservatively than society in general? And that's where you have individuals who feel like, hey, this is my right, but does your right outweigh the rights of other people as well as a whole? So that's where you have individuals kind of weigh in regards to that. So individual liberties versus security. The U.S. is one of the most individualistic countries on earth. France is number 1. People can deviate from the norm. In other words, freedom and personal autonomy are 2 of our most deeply desired values. People need to feel secure. In other words, society has a vested interest in discouraging risk that might injure the individual or others as it creates a burden on society. So again, in our country, we try to pride ourselves on the individualistic elements. If you remember, when COVID hit, you had individuals who were criticizing both ends of the spectrum. Some were indicating, we should have locked down the borders. Others indicated, well, it's my right to go about, without having to wear a mask. And again, each one is valid, but again, you're also looking at the element of, which one outweighs the other. So, rights of individual versus the common good. Consider U.S. Supreme Court decisions since the 1960s with respect to the rights of criminal suspects and defendants versus the rights of crime victims and the power of the police. So again, in the 1960s, the Supreme Court established a number of principles that provided or expanded explicit rights for those suspected of breaking the law. In other words, the Miranda Rule, guaranteeing the right to remain silent. Again, those are things that allow you to be protected as an individual. If, say, for example, an individual is detained, and as they're detained, the police come in and start questioning, and that individual that is detained indicates, I want to speak to a lawyer, I'm not going to say anything else. Again, the police has to respect what that individual has said, and they will not ask any more questions, because if they ask any more questions and the individual has already stated, yes, I did request for a lawyer, but later on, all of a sudden, I didn't get the lawyer, but the police officers still kept questioning me, and I started telling them everything I needed. Again, some would consider that intimidation, some would consider that coercion, and again, those are elements that can get the initial case thrown out. So again, that's kind of the uniquenesses in regards to having rights. So again, many of these rights were trimmed later when courts ruled in favor of the police. Again, the Supreme Court ruled that the police can stop a motorist whom they believe has violated traffic laws, even if their ulterior motive is to investigate the possibility of illegal drug dealing. Again, here's a little cartoon on the side. You have the right to remain silent. Anything that has been secretly given to us by the NSA can be used against you, and we can conceal that information from you, your attorney, and the courts. But it's one of those uniquenesses where you have individuals who suspect, or they may suspect a given crime be broken, and therefore they may end up going in another direction, but they may be trying to find a different avenue to charge the individual. So again, there are two models of the criminal justice system. The conflict between the rights of the individual and the rights of society is related to a distinction between the due process model and the crime control model within the criminal justice system. So again, you're looking at due process, in other words, fair trial by jury, versus the other, which simply indicates the majority of the burden being held by the judge itself. So again, individuals versus the common good. Due process model was favored in the 1960s. Again, the due process model places the primary values on the protection of citizens, including criminal suspects, from possible abuses by the police and the law enforcement system generally. So again, that's one of the things is we have the due process system that we utilize a lot of. And again, it's just to initially protect the individual, even if they are criminal suspects. So again, that's where you have individuals who are incarcerated who will indicate, I know my rights. And for lay individuals, they'll look at it from the angle of, well, you don't have rights. But the reality is, yes, they do have rights. And within that, those rights still have to be respected. So here, the due process model assumes the innocence of suspects and requires that they be treated fairly by the criminal justice system. And this is where individuals their emotions play in. Even if they go through the due process model and they are tried and the jury acquits them, our emotions still play into it because, again, even if they are acquitted, individuals will still feel like, hey, I can't call it, I can't prove it, but, I have this feeling. And if you notice, we don't really go by feelings, we go by facts. And so that's kind of where a lot of individuals still, how would you call it? They still hold on to those various reserves, and that's the reason why it kind of can become a little cumbersome in moving forward. Thus, the due process model emphasizes the rights of the individual over the temptation by society to assume suspects are guilty even before the trial. And this is where things kind of get dangerous, is if you simply assume guilt. If you notice, a lot of times if we go that route and if we have no initial evidence, it can actually come back to haunt us. And I think that's where we saw it in regard to the Innocence Project. So here you have the crime control model, which again was favored in the 1990s. The crime control model seeks the apprehension and punishment of lawbreakers. Again, the goal is to ensure that criminal activity is being contained or primarily reduced. Again, the 3 strikes life term. In other words, California has a 3-strike law, which equals 25 to life. Maximum penalties for select crimes. One of every 32 Americans is either incarcerated on parole or on probation. And so within that, you're starting to see some shifting happening in regards to the laws and everything else. But again, this is the crime control model. So then you have the principles. The principle of equality means that all people who commit the same crime should receive the same consequences. But blind adherence to equality can lead to unfairness in situations in which the particular characteristics of offender, victim, or offense matter. And that's where discretion can be and should be needed and required. So all people should be treated equally, and no one should receive special treatment by the court simply because he or she is rich, influential, good-looking, etc., etc., etc. But you see that here and there. However, there have been incidents that suggest unequal treatment of citizens by the legal system, in other words, profiling. Again, this is more of racial profiling, not necessarily criminal profiling. Again, viewing certain characteristics as indicators of criminal behavior. But again, it also can span into that area. Individuals who are of low income primarily fall into that category. Individuals that may fit a certain criteria in terms of physical features. But again, as noted, and I know that's where we always try to look at it from the angle of, there should be complete discretion. But just as with anything else, mistakes can be made, and within that, that's where a lot of times individuals end up falling into that unique rut. So racial profiling. Between 2004 and 2009, police officers in NYC stopped approximately about 3 million people. 52% of the people stopped were African Americans. 30% of the people stopped were Hispanic. Again, most were young and poor. And again, that's one of the things you kind of look at. You look at those impacts of racial profiling and how that skews initial judgment. And I think we see that also in the Navajo Nation, where you have individuals who may fit a certain criteria based on clothing, based on just physical features, physical abnormalities. And within the area that I used to work in, like I said, I used to work with inmates, and one of the biggest elements that you end up coming across is just the aspect of just respecting one another. When you're working with inmates, whether they have tattoos on their face, whether they have this, that, and the other, just simply respecting that individual, it can go a long way in terms of working with an individual. Because again, like I said, a lot of individuals end up committing a crime at a time when they were at a unique standpoint in their lives. But again, I'm not saying that I'm justifying their behavior. Rather, I'm simply indicating that at times, you kind of have to take into consideration that level of discretion. So again, the principle of equality, relevant to the issue of equality under the law, the U.S. Supreme Court has occasionally applied a principle of proportionality. In other words, the punishment should be consistently related to the magnitude of the offense. And again, since psychosocial immaturity renders juveniles less culpable and more likely to be rehabilitated, than adult offenders. Again, the U.S. Supreme Court has overturned harsh sentences for juvenile offenders in the quest for equality. And that's where you're going to have various rehabilitation efforts. You see that even on the Navajo Nation. And we'll talk about that later on in the course. Just so long as you kind of get a good inkling of what it is. But again, you want to make sure that there's a level of discretion that is applied. So that because again, when I used to work with inmates, a lot of times I was working more with adult offenders. But at times I did work, when I was working as a counselor, I did come across some individuals who were juveniles and had been possibly, had been noted in regards to going to a juvenile court and everything else. But one of the biggest things you end up coming across is just the element of, is this their first time? Can this person be rehabilitated and everything else? And again, that's one of the things you're always looking at, is making sure that that individual is able to change their mindsets before things get worse. And again, it also comes down to the family input, the familial impacts. If, say, for example, mom and dad are both in and out of the home, if there's a level of alcohol abuse and meth use and drug use, etc., 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 will it influence the child? And the reality is yes. So again, that's where you also take those things into consideration when you're making your judgment. You want to make sure that the individual is assisted to the best of your ability and also to the best of their ability, so that you're able to have a level of success overall. So those who commit murder before 18 cannot be given the death penalty. Roper v. Simmons, 2005. Nor automatically sentenced to life without parole. Miller v. Alabama. Again, juveniles sentenced to life would spend more years behind bars than adults, disproportionately harsh. Evan Miller was sentenced to life imprisonment without possibility of parole at 14, but it was later overturned. So again, if you click on the photo, it'll send you to a website so that you're able to see more information of the case itself. So within that, I mean, it's one of those things where a lot of individuals, their cases were overturned because, again, when they committed the crime, a lot of times they were at a very young age. And as time progresses, you want to make sure that there are changes made overall. So again, the value of discretion. So Troy Davis was sentenced to death for the shooting death of a police officer. Over 20 years, evidence supporting someone else as the murderer became overwhelming. Again, support to stop the execution came from Pope Benedict, as well as former President Jimmy Carter, and also other individuals, even going so far as the FBI Director William Sessions and many others. Again, the Board of Paroles and the Pardons met and rejected the pleas. Again, Troy Davis was executed in 2011. So again, many within the justice system use discretion, hopefully. Again, police officers, prosecutors, and juries. When judges use discretion, it can lead to sentencing disparity. In other words, different judges administering a variety of penalties for the same crime. And that's where you kind of see that level of a disparity. You see a differentiation happening. And that's where a lot of individuals always ask the question, is it really fair? And you're hoping it is. But again, you also see that disparity happening, even for penalties given to African Americans and other minorities. Again, African Americans were more likely than people of other races to receive the death penalty, even when controlling for the severity of the crime. Again, the question is this due to racial biases, or is there even more to it? Again, I leave that for debate, and I'll leave it up to you to debate that question. So to counteract sentencing disparity, many states implement determinate sentencing. In other words, the offense determines the sentence, and judges have little discretion. Judges didn't like determinate sentencing, as they said it makes them feel like robots. But again, it does have that element of not so much discretion, but it has an element of shared, I want to say shared collaboration, but that's not the right word. But it's along the lines of having that element of Say, for example, if I'm 30 and I commit a murder or I commit a crime of robbery, or again, it's going to be equal across the board. And so if somebody comes along and also commits the same murder or the same crime, they would be sentenced across the board as well. So it kind of makes more of a streamlined element. Again, recent decisions have moved away from determinate sentencing and enable judges to have more discretion again. So the third choice, to discover the truth or to resolve conflict, because truth is often elusive. The most important priority of a trial may be justice, and we're hoping that is. Because the lawyers believe the purpose of a hearing or trial is to win disputes, they present arguments supporting their client's perspective and back up their arguments with the best available evidence. So here you have the procedural justice. When both sides believe that they have had the chance to be heard, participants are more likely to feel that they have been treated fairly by the system, and the system is more likely to be considered effective. Again, this is an important part of a theory known as procedural justice. So again, respect, trustworthiness, voice, and neutrality. Again, you have it there. So again, respect, are all treated with respect and dignity. The trustworthiness, decisions makers convey trustworthiness as well as a level of motives about those impacted by their decisions. And then it gives a level of a voice, are all given a chance to tell their side of the story. And that's one of the biggest things you're always looking at. You want to make sure that the individuals that are part of the key players, you're hoping that they're able to share their side of the story. And then it leads to a level of neutrality. In other words, the decisions that are unbiased and guided by transparent reasoning can be presented and set forth. And so that's one of the things you're always looking at, is making sure that the system, the justice system, is fair. And I guess that's really what you're really trying to hope for. So again, resolutions and plea bargaining and settlement negotiations. Again, plea bargaining. So what is that? Again, it focuses on resolving conflicts rather than determining truth. Again, you're looking at the elements of saying, okay, rather than finding the truth, I really don't want to find the truth. I just simply want to move on from what issue that we're in dispute over. And that's where you have individuals who are willing to say, I admit that, yes, I did commit such and such crime, and I'm willing to pay whatever restitution so that I'm able to take this plea bargain and move forward rather than go through the trial. Because the trial, again, if you go through the trial, you're damned if you do and you're damned if you don't. In other words, if you go through the trial. You go through it, you're hoping for the best, but the reality is sometimes it doesn't play out the way that you thought it would play out. And it can also have negative outcomes, even for those involved. Even the ones who thought that they were going to have a positive outcome may end up having a negative outcome as well. Again, between 90 and 95% of defendants initially plea a bargain. Again, they accept the offer of the prosecutor and plead guilty to a lesser charge. And that's where you have individuals who will kind of say, I did break into that person's home, but I'll go on a lesser charge of I was intoxicated, such and such, and I'll go with that one, and I'll just simply pay the restitution elements and everything else and kind of go from there. So again, that's one of the things you're always looking at, is the plea bargain will kind of look at the element of being charged with a lesser charge, or a lesser, And so that's where you have individuals kind of going that route. But a plea bargaining. So in other words, the state benefits by avoiding the expense and trouble of trial and the possibility of an acquittal, and by attaining the testimony of the accused person against other involved in the crime. So if there's multiple individuals that were involved in a crime, and the state does not have any knowledge of that, or maybe they have an inkling of knowledge about what's going on, the individual may plead to a lesser charge in order to share insights of an additional criminal network, or if they're part of a gang, sometimes individuals will kind of give up the name of other gang members and stuff like that. So again, the defendant benefits by receiving some kind of reduction in the penalty imposed. Again, that's one of the things, is some defendants will just simply get a slap on the wrist. So that's where individuals, families, and people that are involved, sometimes they don't like it. Sometimes they feel like, hey, this is not fair. and everything else. I want to go through trial, but again, like I noted, trials are pretty expensive. The impacts of trial and everything else, and it's pretty lengthy. Trials are pretty lengthy. They're not like Law and Order. They're not like all the different crime shows out there. A lot of times we see it, and it happens in 2-3 hours, or even an hour, or even primarily in that 30 minutes. They go to trial, it's over, everybody wins, and they move forward. But the reality is, it's more nerve-wracking. If the victim is involved, sometimes the victim does not want to be. Sometimes the victim doesn't want to be displayed. Sometimes the victim does. It has an emotional toll on the victim as well, or even the families of the victim. Even for that, individuals who work, what can happen is you're having to take time off to attend, the trial and everything else, which impacts your financial status. And like I said, it has all these different trickle-down effects. So it kind of just has those various uniquenesses. Hold on. So here you have the civil justice system uses a procedure similar to the plea bargaining to resolve about 90% of the conflicts between plaintiff and defendant. Again, that's where settlement negotiation play in which a plaintiff agrees to accept what a defendant is willing to offer to end their legal disagreement. In other words, conflict resolution. So again, that's where the element of truth versus conflict resolution, which one is more beneficial? Individuals have kind of weighed in on this, where they say, hey, I want to look for the truth, but to what extent? Initially, for the Narration, a lot of times you're doing a lot of restitution. So again, the element of looking for truth is not necessarily paramount. You're just simply wanting to say, okay, I want to simply move on from this given incident. So this is where therapeutic jurisprudence comes in. Again, legal procedures and institutions that facilitate therapeutic ends. In other words, drug court that focus on treatment, as well as even, say, for example, DV court. You have domestic violence rehabilitation programs. You have juvenile rehabilitation programs. And anytime you're trying to utilize a different avenue, you have even individuals who, say, for example, will go with traditional means. Traditional means meaning the individual may, say, for example, go to traditional counseling and have initial traditional practitioners initially weigh in that they will offer some level of counseling to the individual, and within that, that's where the therapeutic jurisprudence will come in as a means to help the individual. In other words, rather than simply punishing the offender, they're looking at another avenue. They're looking at simply rehabilitation. They're looking at a level of resolution to the point where the individual is able to have a better outcome versus simply just incarceration. So again, not all divorces are contentious. Sometimes when you look at a divorce court, a lot of times many divorcing couples choose to work together to determine child's custody. And a lot of times individuals, believe it or not, sometimes even divorces can be amicable in terms of the fact that they're able to work together towards a common goal. Even though the relationship may have ended, they look at the forefront of their children. They look at the impacts that the divorce may have on their child, so therefore they'll try to work things out to the extent that they'll ensure that the child is taken care of in terms of family assets and payments and et cetera, et cetera, et cetera. Again, this represents a form of conflict resolution. So if you were, you can click on the cartoon for a larger picture of the image itself. So again, that's kind of another avenue. So again, laws, they do rely on precedents. Psychology relies on scientific method. Again, psychology is generally committed to the idea that there's an objective world of experience that can be understood by adherence to the rules of science. Therefore, the systematic testing of hypothetical elements will be applied by observation and experimental methodology. Again, that's what you're looking at. You're looking at the materials, the procedure, the hypothesis, the conclusion, and an initial statement. So science versus the law. Legal experts rely on precedents as well, ruling in previous cases, as
well as the Constitution and the statutes for guidance. A lot of individuals always try to change the laws immediately. The reality is if we change the laws too quickly, what will happen is you'll have numerous laws that can end up counteracting one another, and that's one of the oddities. That's the reason why a lot of individuals, that's the reason why laws take so long to change, because again, we may feel like in the present moment, like, this law would be perfect and great and everything else, but bear in mind that if we change it just for your own, just for that immediate case, what can happen is later on, it can have an impact not only just on yours as in that moment, but it can have an impact on others in the future. So again, the principle of stare decisis, let the decision stand, reflects on the importance of abiding by previous decisions, again, is important in this process. So laws, again, they deal with absolutes. Psychology deals with possible probabilities. Lawyers prefer absolute statements. She was or was not insane when she committed the crime. Versus psychologists would prefer to think in terms of probability. In other words, her delusional thinking could indicate a psychiatric disorder. So again, you can notice the difference. Lawyers primarily black and white. Psychologists kind of come from a more probable state of mind, in terms of just simply looking at it and saying, okay, there's a possibility that may be true, or there's a possibility that there's another avenue. So again, that's what you're looking at. You're trying to make sure that you're working within those initial boundaries. So again, laws support contrasting views of reality. Psychology seeks one refined view of reality. Judges and jurors must decide which of two conceptions of the truth is more acceptable in light of conflicting facts. And the psychologist's goal is to integrate conflicting findings into one refined view of the initial truth. So psychological research can be conducted to assist the courts and law enforcement. For example, visual perception can help us understand the accuracy of eyewitness testimony. Research on memory can help people understand repression and long-term forgetting of a traumatic event. A lot of times, what do we usually do is we look at from the angle of regression. We look at from the angle of memory retention. An individual may see an initial traumatic event and may repress that, versus another police officer who comes on scene may say, I just need the facts. I need you to tell me everything. And the reality is, in that moment, there's adrenaline happening, there's stress happening, there's all these different factors that are playing in. And it may skew their initial judgment. That's the reason why at times a law enforcement officer will not only just interview then, but even 2 or 3 days later, they'll re-interview just to make sure that the statements are pretty much the same. But also the individual may end up remembering things later on. And then research of social attitudes and behaviors can clarify why people obey or don't obey the law, as well as who is likely to become a terrorist. So again, you're looking at those different factors. You're trying to make sure that you're weighing in so that you're able to see everything initially objectively. So here you have 5 distinct roles for psychologists in the legal system. A lot of times you have the basic scientists, the applied scientists, the police policy evaluator, forensic evaluator, as well as the consultant. For each role that a psychologist can choose, there are ethical standards of behavior. Again, sometimes the principles specified by these ethical codes conflict with the psychologist's legal responsibility. Example, the obligation to protect clients' confidentiality when they have threatened to harm others. In other words, the Tarasoff decision. Within that, you have the ethical elements of, am I obligated to protect my client's confidentiality when they've also indicated that they want to harm somebody or even harm themselves? So again, that's where you have the limit of confidentiality. Again, that always begins at the beginning of every assessment or the beginning of every time you're going to offer some level of therapeutic help or therapeutic assistance, or even clinical or even psychological help or assistance. You want to make sure that that's paramount. One of the biggest things I always do when I used to work with counseling, whether it's with inmates or whether with victims, I always indicate the limits of my confidentiality. If there's suspected child abuse, or if there's elements of possible suicidal ideations, or even thoughts of wanting to harm yourself or others, I would have to breach confidentiality. And again, that's one of the things you kind of begin with when you're working with an individual. And every time you're doing a session, I always try to make sure that individuals understand that this is what's going to happen, this is how it's going to play out, and this is what policies and procedures that are in place. And majority of the time, a lot of individuals, when they come in, they're understanding of that. They understand the limits of confidentiality, and so they initially are willing to work within those boundaries and everything else. Rarely have I had an individual where they're like, this is ridiculous. I don't agree with it. And even if they don't agree with it, that's where you have the discretion to initially say, hey, maybe we need to limit this level of therapeutic, or limit the level of what I need to be proffering assistance with. And so that's where you kind of have that discretion as well. So the ethics of the basic scientists. Basic scientists, like all psychologists, must adhere to the standards of ethical conduct. They cannot fabricate or forge data, plagiarize, present a skewed selection of data to hide observations that do not fit their conclusion. And also they must treat human subjects in an ethical manner. In other words, revealing any conflict of interest if it arises. Conflict of interest can arise in various ways. Even on the Navajo Nation, if you're a psychologist and you're offering assistance, bear in mind that if a relative comes in, that would be considered a conflict of interest. Say, for example, even offering assistance when you're also a therapist and also offering forensic evaluation, and you end up coming across a client that is also coming to you for therapeutic help, but you're also offering forensic help. And that's where the conflict of interest was. In other words, you would have dual roles, and so again, that's where multiple roles can also create ethical conflicts. And applied scientists seek to do research to solve real-life problems. In other words, psychologists might testify as an expert witness and have testified in such cases as employee discrimination, the effects of posting warning signs, or safety instructions on potentially dangerous equipment, the factors that may cause a suspect to make a false confession, and lastly, the effects of suggestive questioning on children's memory of alleged abuse. So again, these are more of practical applications within the field, not so much of a theoretical element. Well, again, it is still a theoretical element, but it's more of a hands-on approach to psychology. And ethics of a psychologist as an expert witness. An expert witness is usually hired and paid by one side. And that's where the element of bias can also play in. Again, they are still responsible for reporting all of their conclusions, whether it favors the people paying them or not. When experts are blinded, they are seen as more credible witnesses. And blinded simply meaning that they're being unbiased. Each state maintains standards to determine whether or not, or whether testimony of an expert can be used in court. So again, if you click on that one, you'll kind of have an understanding of misrepresenting this individual. Again, you have an individual indicating, I make things up when I can't remember. Again, what kind of expert is this? Lies for a killer. So again, you can click on that. It'll kind of explain what had happened, and it'll kind of give a rundown. Again, that's where you have individuals who fabricate the truth. So a policy evaluator of the law provides data to answer the questions. How do I know what the policy I have instituted is effective? How do I design a change in my organization that it can measure whether it works? Will chemical castration of rapists reduce the number of sexual assaults? Will changing the number of passengers allowed in teen drivers Driver's cars reduce the number of accidents while increasing police foot patrol, improve community relationship. So again, all these things, different elements kind of go into the area of policy evaluation. And then psychologists were tasked with determining whether long-term administration segregation was effective or detrimental to inmates. In other words, they compared the psychological deterioration of inmates segregated with those allowed in the general population. Again, they evaluated whether mentally ill patients deteriorated faster when segregated. Again, I asked that question of, what are your thoughts? You have individuals who, when segregated, a lot of times you'll see their decline, and the reason why is even for the toughest of tough, you have individuals who, again, were very social creatures, and that's one of the things. Even most individuals, they may not have a million different friends, but they'll still have somebody that they can rely on, whether a close friend, a close companion. And within that, that's what we rely on even in our everyday lives. So when we have segregation, what's going to happen is you have an individual who is simply pushed away from the initial general public, initially ousted, which can impact the mental health of that individual. So policy evaluators, segregated group and the mentally ill group showed elevated levels of anxiety, depression, hostility, anger, psychosis, and withdrawal, as well as alienation. And just like I said earlier, again, those are kind of the uniquenesses. But again, the segregated group did not show deterioration over time as expected. Both the general population group and the segregated group showed the same pattern of change over time. So again, is the segregated group, I guess the element is, is the fact that they're initially segregated as a whole impacting their overall mental deterioration. As bear in mind, they are also segregated from the general population of everyday individuals who are non-incarcerated. So the ethics of the policy evaluator is the same as that of an expert witness. They must adhere to the principles of the scientific process. There will be pressures to bend the results, to interpret the results in favor of their employer or source of payment. So here you have a forensic evaluator in litigation. Again, psychologists are secured to evaluate individuals in civil and criminal cases to initially look at the competency of a defendant, the mental state of defendant at the time of the incident. In other words, you want to make sure that the individual understands, not understands, but you want to kind of look at their mental state. Was it a crime of passion? Was it this, that, and the other? Say, for example, for domestic violence cases, if, say, for example, the person was cheating and the partner found out, is it going to impact their mental health? Yeah, you're going to see a crime of passion. You're going to see all these different elements that kind of weigh in. And then also the degree of emotional or brain damage suffered by a victim. You want to make sure that the victim is able to understand what has happened also to them. In other words, what was their emotional distress as well? Is the crime of what has happened extremely impactful to the point where the individual cannot carry on with their everyday life and stuff like that? And then you also look at the effects on a child in regards to custody issues. You want to make sure that you're in favor of the child in regards to divorce cases, to make sure that the child is getting the best benefits in terms of their given needs and everything else. Then also the risk of future violence or criminal behavior. In other words, dangerousness. You want to make sure that you're evaluating for the level of dangerousness. Is this person going to, if they're on a parole, if they're on the initial elements of on a parole board or anything else, is this individual rehabilitated enough to the point where the individual is able to make those necessary changes so that they won't harm anybody else later on in the future? And then there are prospects of for a convicted defendant's rehabilitation in prison or on probation, as I noted earlier. So, two different ways that mental health professionals become involved is one, they're either court appointed, or two, hired by one of the parties, whether defense, prosecution, or even the plaintiff. As I noted, the prosecution will also is working for the state or for the nation. So again, that has to be differentiated. A lot of times and I worked with victims where they were like, all they wanted was my testimony, but it didn't work in my favor. And that's where you have to kind of explain to the victim and indicate, that they're not necessarily working for you. They're actually working for the state, or they're working for the Navajo Nation. And then you have a forensic mental health examination cannot take place unless it is approved by the court. So, no area of psychology is as regulated as that of the forensic evaluator. Again, they must comply. They must comply with the ethical codes as specified by the APA. And then you also have the specialty guidelines for forensic psychologists. Then you also have the guidelines for child custody evaluations and family law proceedings. Again, these also evolve as well. These also can change. And as they change, you want to make sure that you're adhering to the most recent ethical codes. I always have students who always ask the question, why? Why do they change it? Again, we're a societal. Our laws and our systems and even our psychological evaluations are all based upon societal norms. So again, there are changes, there are modifications, there are different ways that we evaluate and different ways that we interpret information. And therefore, these ethical codes end up getting updated as well due to those uniquenesses. So forensic evaluators, again, when they're providing evaluation, they must be clear in their purpose, and this is where writing is very crucial. You want to make sure that it's conducted by an individual who are competent by virtue of their education, training, and experience. And I know that Navajo Nation is kind of a unique location. One of my mentors, great individual, used to be a health psychologist. But as a health psychologist, because he was the only psychologist out here on the Navajo Nation, at times he would have to do various competency evaluations. So again, it's one of those things where under special circumstances, you end up having to do and also having to implement your own judgment. But again, it is always favored that you get the necessary training when you're applying yourself within the field of legal psychology, because again, a lawyer will tear it apart. So again, respectful of appropriate relationships, in other words, avoiding multiple relationships. And this doesn't mean personal relationships. I think this is where a lot of individuals have kind of gotten confused with this. This doesn't mean your own personal inklings and everything else. Personal matter is your own personal matter and everything else. But this is talking about multiple relationships on a professional standpoint. Say, for example, you're offering therapy and then you're also providing evaluations. And so the fear is that when you're working with an individual, you're not being objective. You end up having to try to treat this individual when your main job was just simply to gather information. So again, that's where you kind of get into those various ruts. And so again, special circumstances kind of also apply, because even on the Navajo Nation, we're very limited in terms of getting in terms of getting the necessary trained individuals. So sometimes this will kind of skew results, but overall, like I said, you want to make sure that you have the necessary training and everything else to ensure that you're offering the best I would say the best insight in that given circumstance or in that given legal issue. And then also providing the appropriate level of confidentiality. You want to make sure that you're not sharing information. I've come across this, and even just in my time working on the Navajo Nation, confidentiality sometimes goes out the window. Again, this also can go across the board. Some individuals will work with social services, and they're working with various entities, Say, for example, one may be working with social services, another may be working with the correctional facility, and another may be working with the local hospital. And so, what ends up happening is the individual may not, the evaluator may not be fully up to breath in regards to ethics regarding confidentiality. And so they may end up sharing information to all these other entities without getting prior approval from the individual that they had evaluated, or even from the entity that has hired them as well. So again, you want to be very studious in terms of that. You want to make sure that you're guarding that level of confidentiality. And then you're using methods that are accurate, current, and consistent with science and standards of practice. And lastly, you want to communicate appropriately. You want to make sure that everything that you're saying actually coincides with what you've actually indicated. And so that's where, for me, when I do a lot of, when I used to do a lot of various educations and everything else, one of the biggest things was just being very clear. When I worked with inmates, being very clear. When I worked with victims, just being very clear. When I worked with lawyers, again, being very clear and concise. At times, you can end up getting caught up in that, and that's where individuals end up getting into trouble because one, they get caught up in that rush of wanting to help, and they end up fudging the truth, or they end up extending themselves farther than they initially can possibly handle. So again, that's always crucial to understand your limitations. And again, there's no issue with knowing your limitations, because then you say, okay, maybe I need to better myself in education, this, that, and the other, versus simply getting yourself into deep water when it could have been easily alleviated just by simply being truthful. And in the 1970s, a new field of psychology opened up. So this is where trial consulting has expanded to include jury selection, community attitude surveys, testing the effectiveness of various evidence, and providing guidance to attorneys, and also preparing witnesses for testimony. So again, that's one of the things you're looking at. And the ethics. The ethics of the consultation and litigation. There's no expectation for impartiality in this role. Psychologists as trial consultants subscribe to the ethical code of attorneys. In other words, ethic codes of the American Bar Association. So herein lies the uniqueness of the interaction of the law and psychology. So that wraps up chapter 1. Very lengthy, and I think you'll understand that each lecture is going to be pretty lengthy because, again, we're going through a lot of information. So again, if you have any questions, let me know. And moving onwards. So tips to reduce psychological toll of divorce. So this is one of them. So again, this is one that if you zoom in, this is where it would show you. So if you have any questions, we'll be moving on to chapter 2. So hopefully, if you have any questions, send me an email. But majority of the time, you're ending up moving forward, and a lot of this is already covered in the reading if you've done the reading. And if you notice, the reading kind of has a lot of information as well. And I kind of just go through the main tidbits that I feel like you need to know in moving forward. So moving onwards and upwards. Have an awesome day.